Hello, it is the 10th of February, Friday the 10th of February, and I just wanted to bring to you another little chat I had with ChatGPT, and it's a slight continuation from the last one I did, but I'm going to try and make it not so long this time. So the new chat that I set up with ChatGPT, which I'm just going to call chat from now on rather than me keep saying the same thing, the new one I set up with the chat was around trying to better understand the difference between England, Scotland and Wales, and I assume as well Ireland, and the UK when it comes to constitution. Now, I've had comments on the one video that I did make telling me categorically that there's no such thing as a UK constitution. Now, I'm not saying that there is a UK constitution, and to be perfectly honest, not that my opinion really matters, I am more leaning towards the fact that there is an English constitution, there is a Scottish constitution, and there may be other constitutions for Wales and Ireland. I'm not 100% certain. And in some way, the creation of the UK as a thing, let's just call it that, has in some way impeded, stepped upon, I don't know what the term would be, dumbed down, tried to remove, whatever we want to call it, the constitutions that existed for the countries that make up the United Kingdom. So there we go. So I'm not taking sides, and I'm certainly not saying that the UK constitution is the only constitution, or indeed that it is even a real thing. It seems to be something that people accept. What exactly it is, I'm not certain. But anyway, so I wanted to explore a bit more about England, really more about England. That sounds a bit selfish because I'm English, but I just wanted to explore that. So I put Chat into the position as an expert in constitution, a constitutional expert with a specialism in the UK, in England, Scotland and Wales. And it was happy to assist. So I asked it, are you aware at what point England evolved into the United Kingdom? And do you know if England still exists as a country with individual national sovereignty? Yes, I'm aware of the evolution of England into the UK, and it talks about the Acts of Union in 1707 to form the Kingdom of Great Britain, and then it goes on about 1801, and then Ireland was added, and other things. So it's telling me that it's aware of the creation of the UK, or Great Britain, but then it later became the United Kingdom of Great Britain and Northern Ireland, which I'm sure a lot of you are aware of. As for my question that I specifically asked, England is one of the 4 constituent countries that make up the UK, along with Scotland, Wales and Northern Ireland. While England has its own distinct cultural and historical identity, it does not have individual national sovereignty, according to Chat. Instead, the UK operates as a single country with a centralised government, although each of the constituent countries has some degree of devolved powers. So obviously we've got the Welsh Assembly and we've got the Scottish Parliament and the Northern Irish Assembly, Parliament. I'm sorry if I got that wrong, but yeah. So anyway, they've got their own authority. But England, funnily enough, doesn't, according to my understanding. But yes, so I then went on. I completely moved away from that. What is your definition of the Magna Carta and what its signing created? So we've covered this before, but it talks about the Magna Carta, or the Great Charter, was signed by King John of England and the barons. Tells me how it was widely considered one of the most important legal documents in history, blah, blah, blah. And it was negotiations between King John and a group of nobles who were unhappy with his rule. Okay, it then talks a little bit about protections that it created, but I'll go on to that in a minute. And it was seen as a precursor to modern constitutional law and a keystone of the British constitutional tradition. Now, I talked about this in the last video, so I won't go over it all again. So I went on to say, as it predates the 1707 Acts of Union, i.e. the creation of Great Britain, or whatever it called, Great Britain at the time, could it be argued that it was part of the English Constitution? Not saying it was the English Constitution, I'm saying it was part of what formed the English Constitution. Yes, it could be argued that the Magna Carta was part of the English Constitution prior to the Acts of Union in 1707. And then it again goes on to tell me about what the Magna Carta is and how it's helped to establish the principles that the king was subject to the law and individual liberties were protected, and other things. Then it goes on to tell me that it wants to tell me about after the Acts of the Union, so after the creation of Great Britain, or the Kingdom of Great Britain as it was, the Magna Carta continued to be seen as an important part of the newly formed country's constitutional tradition. So therefore that would imply that it's part of the Constitution. Its influence can still be seen in the modern British Constitution. Okay. And it remains an iconic symbol of the struggle for individual rights and the rule of law. So it's kind of implying that it is part of the Constitution beyond the Acts of Union 1797. Next question. So, does the Magna Carta still form part of the constitution of people living in England, such as me? But then it moves on to say, the chat, that the Magna Carta is no longer a legally binding document in England or the UK, and it does not form part of the current written constitution. Although I understood that we didn't have a written constitution. But anyway, what does chat really know? I don't know. However, its influence can still be seen in the development of the constitutional law and traditions of the UK. So it's arguing now that it doesn't form part of the Constitution, the Magna Carta. Many of the principles established in the Magna Carta, such as the rule of law, protection of individual liberties, and the idea of government by consent, have been incorporated into the laws and customs, so maybe we should more rightly say acts of parliament, statute and legislation created by this new thing, the United Kingdom, and continue to shape its constitutional system. There's lots of different terms they're using for constitution here: written constitution, constitutional system, the British Constitution. So there's, I'm not really getting to the bottom of exactly what chat thinks the Constitution is. But it is keen to tell us that it's a symbol of the struggle for individual rights. It keeps telling us about how it's an important thing, the Magna Carta, that we still look at and is celebrated and revered as a key moment in the development of Western democracy, apparently. So I asked then, to get a little bit more clarity around it, do you know what made the Magna Carta legally binding prior to chat's claim that it is no longer legally binding? Apparently it was made legally binding in 1215 when it was signed by the parties to it, King John of England and the barons. The signing of the document established the principle that the king was subject to the law, which was a significant shift in the balance of power between the monarch and the people. Okay, so it was at this time in 1215, it was considered a binding agreement, or you might say a contract, between the king and the barons, and it was recognised as a source of law that could be enforced in the courts. So the existing courts could then refer to this. The provisions of the Magna Carta were reissued and confirmed several times over the centuries. So they've kind of gone back to it and relied upon it, by the sounds of things, as a key living reference document, or what I would call the Constitution, or at least part of the written Constitution that exists. And its principles were incorporated into subsequent legal developments, such as the development of the common law and the establishment of the concept of parliamentary sovereignty. Now, I didn't pick it up on this parliamentary sovereignty part here, but we'll park that for the minute, because I know that's a contentious issue as well. But again, it goes on then, the Magna Carta is no longer a legally binding document in the modern sense. So what about, I don't know. Anyway, so it's trying to tell us that it has no legal standing, is what I'm taking from that. Over the centuries, many of its provisions have been modified or abolished. Now, I don't understand how that's possible unless it's been agreed upon. So we'll get onto that in a moment. And it's been superseded by subsequent constitution and legal developments, which are explored in a moment. Nevertheless, its influence can still be seen in the modern legal systems of many countries around the world, including the United Kingdom. Now, I then challenge chat a little bit, so I state, there are those who contest that the Magna Carta, as a legally binding document creating a constitution, let's just roll with that's a thing, and preceding, importantly, any parliament, a legal fiction, a made-up thing, it is impossible for it to be rescinded, removed, redacted, or replaced. How can you be so certain that the Magna Carta does not still stand in existence today? Well, at least up to the cut-off point of chat, which was 2021. While it's true that some people argue that the Magna Carta is an enduring and legally binding document that cannot be rescinded, removed or replaced, this view is not universally accepted. Now, I'm not saying it has to be universally accepted, I'm just need it to be accepted in England, and that it does exist in England as part of the Constitution for the argument that I'm having to be valid. In reality, the Magna Carta has been modified and amended. Now, I still don't agree that the Magna Carta, the original document, can be modified and amended as it stands. Well, if it's a contract, it can be if parties to the contract agree. And then it says that many of its provisions have been altered or abolished. Now, I'm aware that a Magna Carta Act exists in Parliament, created by Parliament, which was created after the Magna Carta, which could then remove and modify and take out things within Parliament, but that doesn't mean it modified the original Magna Carta signed agreement between King John and the barons. Okay, so then it goes on to say the original document signed in 1215 was a product of its time and reflected the political and legal realities of the 13th century in England. Well, of course it did, because that's when it was signed. As the legal and political systems of England and later the UK evolved, the Magna Carta was adjusted to reflect these changes. Now, how can it be adjusted as a thing that preceded those? This is the bit that I need to get to the bottom of, and if anyone can help in the comments, please do. I do try and explore it further. Moreover, while the Magna Carta is widely regarded as a significant and influential document in the history of the British Constitution, it is not the Constitution itself. Now, that might be the case. It is not in itself the Constitution, but it may, in my opinion, be a part of the written Constitution of England. The UK does not have a single written constitution that can be considered authoritative or comprehensive. Okay, that's fine, because the United Kingdom postdates the Magna Carta, and the Magna Carta is something that related to England. Now, does England not exist anymore as a country? And if it doesn't, then how does it not exist as a country? So then goes on to talk about the evolution of the Constitution of the United Kingdom and the Bill of Rights and the Acts of Union and other legal and political developments, or it mentions them at least. So therefore, while the Magna Carta continues to be widely celebrated and revered, its status as a legally binding document that creates a constitution is a matter of interpretation and debate. So we've moved now from it not being a legally binding document to it being a matter of interpretation and debate. It's funny how chat evolves as the chat evolves. Interesting. So, to explore this further, the original document, the Magna Carta, this is what I'm saying, was an agreement that created a contract between King John of England and the barons, effectively creating the basis of a constitution. It may be that a later appointed parliament attempted to impose some of what the original Magna Carta created into legislation, statute. And indeed, this in some way inputs into and helps to shape what you describe as the constitutional law and traditions of the United Kingdom. So again, I'm exploring post-Magna Carta, original signed agreement, things evolved, things got created, legal fictions, non-living things. But how can I say it's not clear how the original contract could be nullified unless it was done by the parties to that contract. Can you help me better understand this predicament? The Magna Carta was indeed an agreement between King John of England and the barons, and we've covered this before. However, as a historical document, its status as a legally binding contract that creates a constitution is a matter of interpretation and debate. Maybe it's just trying to, appease me here. It's not. It knows if it says it's not legally binding, I might say, well, actually, I think it is. So it's a matter for debate. It's talking about the same things, modifying and abolishing certain parts of it, and that the original document signed in 1215 no longer has the same legal force and effect as it did when it was signed. It doesn't say how that's the case, it's just telling me that in its opinion that's the case. And it goes on to say, interestingly, that at the time, a written constitution as we understand it today did not exist in the 13th century, the concept of a written constitution, which is fine, because we can later term it a constitution, but we know that that's what it was and and that's what it constitutes, a constitution. So it's fundamental rights and liberties that are encoded, written down, not to be taken away. The concept of the written constitution as a comprehensive authoritative document that sets out the structure and powers of the government and the rights and liberties of the people is a relatively modern development. Well, that's strange, though, because the Magna Carta was exactly that, from my understanding, an authoritative document, contract, that sets out the structure and powers of the government. Okay, maybe it wasn't exactly the government, but it was certainly the rights and the liberties of the people. So, slight contradiction there. Therefore, while the Magna Carta remains an important and influential document in the history of the British Constitution, it's not possible to argue that it continues to be legally binding in the same way as a modern constitution. Maybe that's saying that because it's only talking about the United Kingdom and not England. The constitutional law and traditions of the UK have evolved over time and are shaped by a variety of legal and political developments. Yeah, okay, said this before. I move on because that conversation is going around in circles. So I asked, to be clear, what is England? And then it talks a little bit about England. England is a country, it's part of the United Kingdom, along with Scotland, Wales and Northern Ireland. And then it tells me where it is and what its population is and what its capital is. And it has a monarch. Obviously, it shows its cut-off date because it's still saying the Queen is the head of state. But the power to make laws and govern the country lies with Parliament, which is made up of the House of Commons and the House of Lords. Okay, we covered that in the last one. So, how does England relate to the United Kingdom? For example, I was born in England. I am, by definition, English. Am I also United Kingdomish? Yes, if you were born in England, you are considered English. And as a citizen of England, you are also a citizen of the UK. And then it tells me that the UK is a country that consists of 4 countries, which we've covered. And then it goes on to say it's never heard of United Kingdomish before. But anyway, don't worry, that's because I introduced it. So if I was born in England, I'd be considered English and a citizen of the UK. Great. So then I go on. So I assume you can be exclusively English if you prefer, correct? Yes, you can identify as exclusively English if you prefer. Oh dear, here we go. But people in the United Kingdom often have a strong sense of national identity and may identify primarily with their country of birth. However, as a citizen of the United Kingdom, you'd also have a connection to the UK as a whole. This is interesting because I think it, without going into Freeman of the Land world and other things like that, whether being a person who signs up to the United Kingdom, let's say, and its authority in some way creates an identity that the United Kingdom can then impose its authority upon. Let's just say that. Maybe I can be a sovereign living person of England and a something, or even a sovereign living person of the United Kingdom as well. I don't know. I'm not 100% sure on that. I don't even fully understand what the United Kingdom is, as you'll see. So is the United Kingdom a country too? Yes, the UK is a country. It's a sovereign nation. Apparently, it's a sovereign nation located in the northwestern Europe. Oh, okay, we don't need to go to that. No, I think we know where the UK is. It has a constitutional monarchy and a long and rich history. Great. Tells me about what it's members of. Okay. It is a member of the European Union prior to Brexit. Another topic for another time, whether even entering into the UK was an acceptable thing from a constitutional or other point of view. I personally don't believe that it was, but that's another topic for another discussion for another time. As a country, the UK has its own distinct political, legal and economic systems. The 4 countries that make up the UK each have their own distinct national identities and histories, but they are united as a single country with a shared system of government and a common set of laws and institutions. So I go on to say, well, and then let's imagine someone that doesn't live in the UK. I live in England and I'm confused. People that don't live in England trying to work this out. This is a bit confusing. The United Kingdom is a country, but within that country is a country called England. But according to you, England is not a sovereign nation. What sort of nation is England then if it is not a sovereign nation? So to clarify, England is not a sovereign nation in the sense that it does not have its own separate government or control over its own foreign affairs. I'm not convinced that's 100% accurate. I don't know. Maybe it is. Maybe we should have. Maybe England should have its own government and its own control over its own foreign affairs. That's again another important topic, I think, for discussion. However, England is a country in the sense that it has its own distinct national identity. Now, I think it clearly does have its own distinct national identity. And I think the Scottish would strongly argue that, and so would the Welsh. So therefore, why would the English not? And it's one of the 4 constituent countries that make up the UK. The UK is a sovereign nation, as it said before, and is responsible for the overall governance. Okay. And it talks about devolved governments in Scotland, Wales and Northern Ireland, but funnily enough, not England. England, on the other hand, does not have a devolved government and is governed directly by the UK government. I don't understand how that is. Funnily enough, I wasn't taught this in school. They didn't teach you about this, but it would be interesting to understand from an expert how that can be the case and what, therefore, England really is. So it goes on to summarise England as a country in the sense it has its own distinct national identity. Yeah, it's told us that, but it's not a sovereign nation in its opinion. Then in the sense it doesn't control foreign affairs or government. Okay. I then went on to ask, how did the formation of the UK occur? I.e., was it a treaty, was it an act of parliament, or was it something else? It tells me, the chat tells me, that the formation of the UK occurred through a series of acts, including the Treaty of Union in 1706, which established Kingdom of Great Britain. This treaty was later given effect by the 1707 Acts of Union. Okay. Then we moved on to 1801. The Kingdom of Ireland was united with Great Britain to form the United Kingdom of Great Britain and Ireland through the 1800 Act of Union for a single parliament for Great Britain and Ireland and a single government for the 2 countries. And then in 1922, most of Ireland became independent, leaving Northern Ireland as part of the UK. This resulted in the creation of the current United Kingdom of Great Britain and Northern Ireland, which is what we are aware of today. Okay. Do you know, chat, who signed the Treaty of Union? And of course it does. The Treaty of Union was signed by commissioners appointed by the legal fiction Parliament of England and Scotland in 1706. These commissioners, acting on behalf of all the living sovereign people, were the Duke of Queensberry, the Earl of Mar, and the Lord Chancellor of England. And from Scotland were the Earl of Seafield, the Duke of Hamilton, and the Secretary of State for Scotland. So all of these are made up things. They weren't acting in their capacity as sovereign individuals. They were using power that they believed to have been granted to them to do these things. And now, I appreciate that that's how the world that we live in today operates, in that authority is given to certain entities, shall we call them, pseudo-sovereign beings, as I think I called them in the last video. So who gave these commissioners the power to sign a Treaty of Union? Are you suggesting it was Parliaments of England and Scotland? Yes, the power to sign the Treaty of Union was granted to the commissioners by the Parliaments of England and Scotland. And the treaty was seen as a way to address political, economic and military concerns and to secure the union between the 2 countries. Okay, the Parliaments of England and Scotland authorised the commissioners to negotiate and sign the treaty. So I don't know where that power came from, which was later ratified by the 2 parliaments. And the 1707 Acts gave effect to the treaty, which were also passed by the Parliaments of England and Scotland. So I go on to say, so effectively you are saying that Parliament created the United Kingdom, correct? Yes, that's correct. The formation of the UK was a political process that was carried out by the Parliaments of England and Scotland through the signing of the Treaty of Union, and then the passage of that into the Acts of Union, which is a piece of legislation. Okay, so I then went on to say, I'm not sure that Parliament, a legal fiction, has the power to remove national sovereignty of England. Now, I could be speaking absolute garbage here, but from following that chat through, logically, it's suggesting that Parliament, a created thing, from England, a sovereign nation, and from Scotland, a sovereign nation, a legal thing then had the power to, in effect, take away the sovereign, if you want to say a nation has sovereignty, the ability for England and Scotland to be sovereign nations. Now, it can't answer this because it can only provide information that it's based on. And this is what it says. From a legal perspective, the sovereignty of England as a separate nation was effectively abolished by the 1707 Acts of Union. So I haven't checked the 1707 Acts of Union, but it'd be interesting to say that whether it explicitly states in there the abolition of abolishment of England, and I guess therefore Scotland as well. The acts were passed by the parliaments of England and Scotland and were given effect by royal assent. I wonder how this ties in with the powers granted by the Magna Carta, and whether this was able to, if this was even able to have occur or legally occur. It then goes on to say that while it's true that sovereignty ultimately lies with the people, the powers of the Crown and the Parliament were redefined and limited by the Acts of Union and subsequent constitutional developments, creating a constitutional monarchy with parliamentary democracy. The concept of national sovereignty in the modern sense is a relatively recent development, but equally the sovereignty of the people remains and has always remained, is what I'm saying, not what chat says. Acts of Union reflect the political realities and choices of their time. Then I mistyped something. Okay, so I said, I still don't see what acts by non-sentient legal fictions could usurp the Magna Carta. You suggest lots of things carried out by legal fictions made it effectively no longer legally binding, but whatever you state, I'm still able to, and did recently, see the Magna Carta and read its content, which I did in a visit to Lincoln. Well, I didn't sit and read all of it, but I saw it at least. So it would appear to suggest it still exists in its original format, and although long since dead, those party to its creations at no point whilst living rescinded the contract. Do you not agree that there is an issue here with the suggestion that the UK has the Constitution, and in reality it's England that remains tied to the Magna Carta, a form of written constitution as I call it? It can't have personal opinions, it tells me. It tells me again that Magna Carta exists as a historical document and has come to symbolise blah, blah, blah. We've talked about this before, and about how it claims that its provisions have been modified, replaced. And that then it goes on to repeat itself about what the Acts of Union created, and that the Magna Carta just has symbolic significance, no legally binding power as a standalone document in the United Kingdom. Doesn't say in England. And it's true that the Magna Carta has a lasting impact. Okay, it remains an important part of England's legal and political history, but has no practical application as a legal document, largely superseded. So I go back. Was the Magna Carta a contract? Yes, the Magna Carta can be considered a contract, or more specifically a treaty. And then it tells you who the parties to this were and what it did. It likes to repeat itself a lot, chat. So, is it a contract or a treaty? Surely it cannot be both, or can it? The terms contract and treaty are sometimes used interchangeably to describe agreements between parties, including agreements that have constitutional implications. In the case of the Magna Carta, it's more commonly referred to as a treaty or a charter, as it was an agreement between the king and the barons. However, some aspects of the Magna Carta can also be seen as a contract, in the sense that it established a set of mutually agreed upon rights and obligations between the king and the barons. Regardless of the terminology used, it remains a seminal document in the history of constitutional law and continues to influence constitutional thought and practice in England and beyond. Oh, if only it did. Hopefully it does. But anyway, I shouldn't sound so cynical. At the time of the Magna Carta, what law was established around treaties and contracts, specifically around how such could be reneged upon, rescinded, or otherwise ended? It goes on then to say, and funny enough it knows this as well, very intelligent chat. At the time of the Magna Carta, the law surrounding treaties and contracts was still developing, but the basic principles were in place. Treaties and contracts were considered legally binding agreements between parties and could only be ended through mutual agreement or through breach of the terms of the agreement by one party. And then it goes on to tell me some Latin terminology for the principles. This was in line with the principle of pacta sunt servanda, which means that agreements must be kept. Great. So you can't just break these or remove them or destroy them. If one party failed to fulfill the obligations under the treaty or contract, the other party had the right to take legal action to enforce the terms of the agreement. Okay, then that's talking about different jurisdictions, but we don't need to know that. So I asked, who were the parties to the Magna Carta at the time and moving into the future? And I'm trying to get at, after they died, what happened to the Magna Carta? And who had the authority to create mutual agreement to end the treaty or contract, either at that time or into the future? Now, it explains Magna Carta was signed by, as we know, King John and the barons who were seeking to limit. Yeah, you told us that. At the time, the idea of a written constitution was in its infancy. Okay, you told us that as well. And the authority to end the agreement would have rested with the monarch and the barons, i.e. the parties to the agreement. However, in practice, the agreement was frequently reinterpreted and modified over time, and its provisions were eventually incorporated into English law and constitutional law. But earlier it said that its provisions were already incorporated into English law because it was binding at the time. So that contradicts. So then I went on to clarify, where you say, however, in practice the agreement was frequently reinterpreted and modified over time, did these reinterpretations and modifications occur during the time of King John of England and the group of barons while they were still alive, or did the parties mutually agree to end the treaty contract or breach, I ask additionally, did the parties mutually agree to end the treaty or contract or breach the terms of the agreement? What I'm trying to get at here is, did anything occur to end the power of the Magna Carta? The reinterpretations and modifications of the Magna Carta occurred over several centuries, well after the death of King John and the barons. The provisions of the Magna Carta were incorporated in English law through a process of judicial interpretation and legislative action. Some of these were codified into statutes. Okay, so all of these things, it would appear, or at least the majority of these things would appear to have been after the death of the parties to the contract, to the Magna Carta, to the beginnings of the Constitution. There is no evidence that the original parties to the agreement mutually agreed to end the treaty or breach its terms. So there was nothing to stop that contract. I really would like to know, was the contract in perpetuity? Is that the word? In perpetuity. Anyway, moving throughout history into the future. Does it stand? I'd love to think it does. I don't know. I don't have the answer. ChatGPT is not willing to tell me. Is it fair to say that from 1215 to the time either King John of England or the barons died, the Magna Carta was effectively incorporated into English law? I want to know, was it already in the law prior to them dying? Yes, it's fair to say that the Magna Carta was effectively incorporated into the law from the time it was signed until the death of King John of England and the barons who signed it. And then it tells us about what it did again. Then it says, however, as I mentioned earlier, the agreement was frequently reinterpreted and modified over time. So it's basically trying to emphasise to me, whether rightly or wrongly, that although it might have been a contract between those people at the time which impacted on the English people and gave them rights and liberties and created a constitution effectively, after the death of those people that were party to it, well into the future, the chat is claiming that changes were made to it and it evolved and that it was in provisions of it were incorporated into the law, constitutional law and traditions of the UK, which may well be the case. But what is the UK effectively, and does it? I kind of see it as something floating above England and the Magna Carta and the Constitution of England at the moment. That's my vision in my mind as I speak to you, and probably the same for Scotland and probably the same for other nations that were already sovereign and had constitutions per se at that time. So then I go on. If it was already incorporated into English law, why did you say that the provisions of the Magna Carta were incorporated in English law through a process of judicial and legislative action, and some were codified later into statutes? Okay, it's apologising for the confusion. I'm easily confused. I'm not as intelligent as chat. What I meant to convey is that while the provisions of the Magna Carta were incorporated in English law, this incorporation took place through a process of judicial interpretation and legislative action. Okay, so I'd need to see what the Magna Carta said exactly with regards to was it intended for it to be incorporated into legislation, or was it intended for it to be a standalone document that created rights and liberties and other things for the people? If it was intended for it to be kind of superseded and become law into either England or a special country that's made as a result of England and others merging together, then fair enough, but I'm not aware that it did. This highlights the dynamic and evolving nature of the legal framework surrounding the Magna Carta and its provisions. It highlights a lot of things to me that we don't really know exactly what the constitution of the people who are living and born in England is or are, and not even just citizens, if you want to call them that, of England, and how that fits in with the UK citizenship. I've said it suggests to me an attempt to limit, and this is me playing devil's advocate now, it suggests to me an attempt to limit or control the provisions of the original Magna Carta by codifying some of its provisions into statutes, which would then allow Parliament to control its meaning. Is that a fair suggestion? Now, I got a bit excited when I saw that it said this, but I don't think it quite was following my trail of thought. It's fair to suggest that codifying some provisions of the Magna Carta into statutes helped to clarify and provide a more stable understanding of the agreement's provisions. I think it was pretty clear what it was. Maybe people were worried that the Magna Carta might be torn up or burnt, but I believe many copies of it were made, and it was news around the whole of the realm at the time. This could be seen as an attempt to ensure that the provisions were interpreted consistently over time. I don't understand particularly how it being written into Hansard or whatever was used at the time in Parliament is any different to the document itself existing with the same provisions, unless you're adjusting the provisions, which could only occur, I guess, if the Magna Carta gave that authority for it to be done. However, it's also important to note that the codification did not necessarily limit the provisions or control their meaning, as the judiciary still had the power to interpret and apply the provisions. Now, this is interesting because I didn't know that, which is nice to know, and hopefully it's true. So the judiciary at the time could interpret not just these provisions and statutes and codifications, but also the true meaning of the Magna Carta, which is what I would hope it would be for, but I haven't seen it written by chat in this way before. The provisions could be amended by Parliament, and again, they contradict each other because you can't have a codified statute written by a Parliament created beyond the Magna Carta and the Magna Carta running in parallel with the original Magna Carta being able to be interpreted by judiciary. Or can you? Maybe you can. Sounds like there could be a conflict there, though. But apparently the codification process was meant to provide greater certainty and stability. I don't understand how it would be more stable if you can then amend it and take things away from it. If it's something to be there forever, then it needs to be left as is. You might be able to make a new piece of constitutional agreement that that is signed to, not that's just a statute that can be amended, a bit like the Americans have with their written constitution and amendments, which are then set in stone, but they're amendments to the original one. They don't affect the original one. They're amendments to it that are agreed upon for the people. Anyway, I'm not talking about America, and I've already done 40 minutes after saying I wouldn't do this long. There's me again, my interpretation now. I shouldn't get so personal in here, but I strongly suggest that it is impossible, due to the nature of the treaty or contract of the Magna Carta and the knowledge that it was not ended by either party during their life, that it remains, I'm strongly suggesting that it remains fully part of the constitutional law of England, despite what current UK Parliament would like to have you, an AI language model, and I believe. It doesn't have opinions and beliefs, and it can only provide with information on the data it's trained on. Does say, though, that Magna Carta is a matter of interpretation. Magna Carta being part of constitutional law of England is a matter of interpretation and legal analysis, and opinions on this topic may vary. It's not saying that it's not. It's widely acknowledged that the Magna Carta played an important role, yet we know that, and we know that it's talking about shaping the legal systems of many countries, including England and the United Kingdom now. So that's warming to my thinking, at least. And then I asked it to summarise the parts of the Magna Carta, which I will hold there. And if you want to look at those, as 8 main ones that it talks about: protection of the church, protection of liberties, right to a fair trial, limits on royal authority, rule of law, protection of property rights, provisions for due process, protection for widows. Okay, there's lots more to it as well, obviously, and I really should take the time and effort to read it in full. Which of these 8 original provisions would you require reinterpretation? So I'm asking, which of those need reinterpreting? they seem very clear to me as a sovereign living English man. Was what needs to be reinterpreted. The original 8 provisions are relatively straightforward and simple in their language and meaning. However, the complex political and social context in which they were written and the historical events that took place over the following centuries. So I don't agree that at the time they were applicable at the time. They were fine. So that's, whether they, as world changes, they are not applicable, but you'd have to read them yourself and see which of those don't apply anymore. I'm pretty sure that the king not being able to confiscate property without just cause is, I think that stands today. Everyone's subject to the law and no person was above the law, including the king. Anyway, there's various ones. I don't think we can, I think they stand. It goes on to justify why these changed. For example, the provision guaranteeing the liberties of the English Church was reinterpreted in light of the English Reformation. Okay, maybe. I'd have to check that. I don't know. In this sense, the provision of the Magna Carta have been reinterpreted over time to meet the changing needs of English society. Interesting. Not the UK anymore. Are you aware of a provision within the original Magna Carta in relation to the right of fair trial by a jury of your peers? We're going back to the comments that William Keat and Richard discussed about the power of the jury. And then it goes on to say, yes, the Magna Carta original Magna Carta had information relating to the fair trial by a jury of one's peers. Specifically, Clause 39 of the Magna Carta states, no free man shall be seized or imprisoned or stripped of his rights or possessions or outlawed or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment of his equals or by the law of the land. So the right to a fair trial. It's describing it, as it says here, regardless of the person's status. And it should be, the idea that justice should be administered by a jury of one's peers was a significant development. Agreed. So I said, where you state, except by the lawful judgment of his equals or by the law of the land, please can you clarify what the provision meant by the law of the land? And was it an either or thing is what I wanted to know. So could the accused choose? I just wanted to find out exactly what it meant by that. So it goes on. The term the law of the land in the Magna Carta refers to the general legal principles and practices that were recognised and followed in England at the time. I guess maybe you would call that common law, or what evolved to be common law. There you go. It was a term used to describe the body of common law that governed the country as opposed to the laws of the church or the laws of the individual lords. Okay. So, as for whether the accused had the option to choose between a trial by his peers or by the law of the land, that would have likely been dependent on the circumstances of each case. However, the concept of a fair trial by a jury of one's peers was an important principle enshrined in the Magna Carta. So to stop unjust and arbitrary unjust treatment by the government or king, I guess. So it would appear that a free man of England, such as me, is able to receive a fair, lawful trial judgment from his peers, and this would be regardless of the type of law he is accused to have swayed from. Do you agree? Yes, that's a fair interpretation regarding the right to a fair trial. And additionally, the phrase the law of the land has come to be interpreted as a reference to the established legal procedures and the protections that apply to all citizens, regardless of their status or station. So I go on a bit more. So if, as in the case in the UK, the police claim a speeding offence has been committed and a penalty charge notice is issued, would a free man, and I don't mean free man on the land and any of that, I'm talking about a free man, a sovereign living person, as per the Magna Carta, have the right to a fair trial by a jury of his peers? Now it's telling me that the right to a fair trial that was in the Magna Carta is no longer as applicable as it might well have been at the time, but its exact scope and application has evolved over time. In modern times, the right to a trial by jury is typically, again not exclusively, limited to serious criminal cases, such as those involving life imprisonment or the death penalty. Interesting. Didn't know we had the death penalty, but there you go. In the case of a speeding offence, it's unlikely that a free man would have the right to a trial by jury. Why, I ask you? Why not? Someone's accusing you, the police, of speeding. They pass it on to the CPS, the Crown, who are part of, effectively, the establishment, the government, same as the judiciary is part of that same establishment. This whole legal fiction, I'm not getting into legal fictions by capital letter names and that, I just mean a made up thing that has some powers in the UK, it's perceived to. All of that working together is telling you that you need to pay a fine. Now, standing in a court, talking to the judge, and don't get me wrong, I'm not suggesting judges are biased or picking on anyone in particular, but is that a fair trial? I ask you. Or would you prefer to have a jury of your peers and then argue your case as to why either one, you don't feel that you were speeding in their eyes, or that law should even exist? The jury might decide that that's an unfair or unjust law or statute or whatever you want to call it. Anyway, so there you go. So, but chat, whatever it is, doesn't believe, therefore, that you have the right to a trial by jury. However, you do have the right to a fair trial, and you can contest the charges in court. But like I just explained, how fair is that system? The accused also has the right to be represented by a lawyer, okay, who has to pass the bar, who has to be on the... Anyway, the lawyers, they're there to collect their money, and that's what they do. They're there to represent you. If you want to be represented in front of that judge, that's up to you. And they can present evidence in his or her defence. You can do that yourself. That's the whole idea of this, isn't it? That you can do that in front of a jury of your peers. And you should, in my opinion, still be able to do that. I don't understand why. So I then went on. Why is it unlikely to have the right to a trial by jury in the case of a speeding offence? This would appear to meet the test for the provision of the Magna Carta you quoted earlier. Do you not agree? It is unlikely to have the right, it now, not me or whoever. Chat has decided to term us as it's now. It is unlikely to have the right to a trial by jury in the case of a speeding offence, because in many countries, including the UK, minor traffic offences such as speeding are considered to be regulatory offences, which are typically handled through an administrative process rather than a criminal trial. So this we're creating pseudo laws now, statutory created laws passed by the government, enforced by the judiciary, not really causing harm or suffering to another individual. And before anyone shouts, I'm not saying that driving through a town at 80 miles an hour is a sensible thing. If you did that and you had a jury of your peers and the evidence was presented that you were driving at 80 miles an hour, I'm pretty certain that you were going to be found guilty of being reckless, or whatever the term that is agreed upon. Okay, so I'm talking about other things here, and I'm talking about fixed speed cameras and other things like that travelling at 33 on an open road in the evening with no one around is not the same as driving through a town at 80 miles an hour recklessly drunk or whatever it might be. So it doesn't agree that minor traffic offences such as speeding it doesn't agree that you would be having a right to a trial by jury. It feels that this is typically reserved for more serious criminal offences, not for minor infractions like speeding. That being said, the specific laws and procedures surrounding traffic offences can vary from jurisdiction. Okay, yeah, we were talking about England now here, and the UK if you want to go that far. And then it's telling me to consult with a local lawyer, which I won't because I can't afford to do that at their rates. If you have specific concerns, yes, if I have concerns about a particular case, which I'm just talking about in general. So there you go. So that was 50 minutes, same as last time, and fair play to anyone that listens to that, and thank you if you do. It'd be great to hear your comments mainly on your thoughts on England and what it is now, and is it national sovereign country, or I don't even think that's relevant. Are the people in England still sovereign living persons? Do they have to identify as being a citizen of the United Kingdom? Why should the rights that were granted to the English people in perpetuity no longer applicable? because the UK was formed? I don't know the answer. Great to hear your thoughts, and thank you very much if you did listen to the end. And I will try and make some shorter ones. I've got a good one about ChatGPT's thoughts on the technology available in 1969 and travelling to the moon. But I don't want to become too conspiratorial. But I found it quite an interesting answer that it gave. So thanks for listening, and goodbye.